In your opening statements, both of the challengers alluded to ideology weighing in on Justice Sanders' decisions, and I wonder if each of you, and we'll start with you, Mr. Wiggins, can give us an example of a case where you believe that occurred and how you would have found differently.
Surely. I think that I view this as an issue of impartiality. The question is, does the judge approach the case with an open mind, and does the judge strive to put aside preconceived notions and biases and to interpret the law in accordance with the will of the legislature and interpret the Constitution in accordance with its language, its intent, the values, and prior case law as well. Two areas that I have focused on regarding a lack of impartiality with the incumbent. One is lawyer discipline. I've been involved in the lawyer discipline system. Cases ultimately go to the state Supreme Court for the final decision on most discipline cases. If you look at the discipline cases that have come before the court since the incumbent has been on the court, and you look at the cases where the court is divided, in other words, they're not 9-0, but there's a split. And that tells you a lot about the thinking of the judges when they are split on a case. If you look at those cases, you will find over the course of his entire career, Justice Sanders has voted against the discipline recommended by the discipline committee and in favor of the lawyer over 90% of the time. Let me give you an example of that. Since the question asked for that, one of those cases is the Day case, a lawyer who was convicted of the felony of child molesting an 11-year-old boy who was a former client of the lawyer. The disciplinary board unanimously recommended disbarment. And by the way, the disciplinary board of the Bar Association is not just lawyers, it includes non-lawyers as well, so there's a significant input from the public. Unanimously said this lawyer should be disbarred. 8 of the 9 justices of the Supreme Court said this lawyer should be disbarred. One justice, that's the incumbent, said no, he should only be temporarily suspended from the practice of law. I think when a lawyer is guilty or convicted of child molesting an 11-year-old boy, I think that probably is a disbarable offense to begin with. But where the boy is a former client and the mother has trusted the lawyer and has really allowed the lawyer to develop a close relationship with the boy, I think it even more merits disbarment. The other area, I don't want to prolong the answer too long, but the other area is the criminal law, where when you look at the pattern of the incumbent's decisions, you see that, again, in the same class of cases, divided cases where the court is non-unanimous, and that's over 350 cases in the course of the incumbent's career on the bench. The incumbent has voted against the prosecution and for the defendant 94% of the time. Certainly he's right in some of those cases, but I think overall it shows an important pattern of failing to consider the cases realistically, failing to consider the interest in public safety, and failing to defer to the jury, because the jury ultimately is the one that finds people guilty or not guilty.
And Mr. Chushcoff, we'll throw the same question to you.
Sure. About half of the cases that are heard by the Washington Supreme Court are indeed criminal cases. And my largest difference with Justice Sanders is there. There are a number of cases in which I think that he has let his political, his passion for a certain political viewpoint color the decisions he's attempted to make. And I'll give some examples. Early in his career was the 3 strikes cases, and there was a couple of cases there. And the issue, of course, with respect to 3 strikes is the legislature was concerned about repeat violent offenders. And with respect to 3 strikes, it was if there was a certain criminal history of strike offenses, which were predefined, and you committed a third or more of those, that the penalty would be life imprisonment. Justice Sanders wrote, if you read his opinion, his dissent on those cases, again, he was in the minority 8-1. His dissent was essentially that this was a cruel punishment under the Washington State Constitution, and it's very well written. It talks about the definition of cruel and from 1893 dictionaries and so on. But the troubling thing about that is that I'm not aware of any jurisprudence in which a term of years in jail has ever been determined to be cruel punishment. And so, as Justice Sanders has put it, he felt that it was too much time given the nature of the offense. which in one of those cases was a second-degree robbery. Another one of the cases, because there were companion cases on that day, was a first-degree robbery and a first-degree kidnapping. And of course, they had prior criminal histories, justifying the third strike. That he simply didn't feel it was an appropriate punishment. My concern is that is not what judges are doing. I'm a professional judge. I do this all the time, where you have to make decisions based upon the law and the facts, uninfluenced by other considerations. And it doesn't matter what I feel about it. The legislature wanted to do something about a particular kind of problem, and this is a choice they made. Is it an unconstitutional one? I don't think so. And I think it took a stretch to try to find it to be unconstitutional. And I think it was that stretch because of how he feels about these things. He's described himself as the greatest advocate, or there's no greater advocate on the Washington Supreme Court for the rights of the accused. Judges should not be advocates for any of the parties in front of them. They should be neutral arbiters and try to be fairly, impartially, and consistently decide the cases that are before them. This is what I do. I sometimes get decisions from the Supreme Court or the Court of Appeals, or the legislature for that matter, in which they have announced a policy that I wouldn't necessarily have preferred, but that's not my call to make. Within the scope of what their responsibilities are, they've made those policy choices. And it matters a great deal because, as you know, judges are insulated a little bit by Canon 7 about what we can talk about. To the extent we discuss cases in a certain kind of way, we can be held liable for prejudging a matter and disqualifying ourselves and so on. And so there are some areas in which we're sort of not allowed to answer the question, and that's sometimes frustrating for all of you in the press and the public and so on. But the point is that when you're running for political office, whether it's a legislature or an executive position, you don't have that kind of protection. And so people are allowed to ask you about your position on taxing and revenue priorities and spending priorities and other social issues that come before the legislature in terms of crime and punishment, what have you. And that's where the vetting for a political philosophy occurs. And if it turns out that the legislature has got a policy, for instance, with respect to 3 strikes, there's been discussion from time to time about eliminating robbery in the second degree as a strike offense. If they feel that over time that the way the thing has been applied, that it's too harsh, well, that's a call that the legislature can make. Just one last finish, if I could. The problem is that when the Supreme Court decides it's unconstitutional, then they foreclose the political discussion, they foreclose the political debate, and they foreclose the political innovation to deal with problems as they arise. Such was the case with 3 strikes, and such was the case, for instance, with sexually violent predator cases.
All right, thanks very much. And of course, we want to give you an opportunity to respond.
It appears that my opponents, in the name of impartiality, want to favor the government in almost every case. I don't take that approach. I think there is a level playing field in the court. The government should be given no deference in these cases. And when a private person fights City Hall, the private person should have the same opportunities as any other party. The judicial system is where I think Justice Deborah Stevens put it, the smallest dog can put its leg up against the tallest tree. And I think it's important that we keep these principles in mind. To try to take the criticisms in order. Mr. Wiggins talks about impartiality. I am impartial, but I think my challengers appear to be partial towards the government. I think that every case stands on its own merits. I don't cite statistics. I look at the facts and I look at the law and I try to apply it. And sometimes I reach a result that I don't particularly like, but that's the way it is. We're looking at legal rights here and we're looking at what the law requires. Lawyer discipline. Mr. Wiggins says that, what was it, 90% of the time I favor the lawyer over the discipline, which is an outrageous falsehood. In the last 2 years alone, we've had about 80 lawyer discipline cases. I have been with the majority of the courts 77 times. One a year in 98 or in 2008 and 2009, I disagreed with the majority of the court. He mentions a particular case where a lawyer was convicted of a sexual assault. And he said, well, Sanders voted to suspend this guy, whereas the other members of the court voted to disbar him. Well, you know, they're entitled to their point of view. I'm entitled to mine, and I support my point of view. I have a copy of the opinion for anybody that cares to read it.